Dwayne Perry, attorney for Mr. Godejohn.
Andrew Mead, attorney for Mr. Godejohn.
All right. Last night, there was a series of things filed. I've received them via email. I've looked through them. Mr. Perry, have you seen them?
I have.
All right. Let's take up perhaps the easiest ones first. The state has filed a motion to amend the felony information against Mr. Godejohn. It looks like there's two changes. One is the spelling of, and the other is the cause of death. Is that correct?
Yes, sir, that it's no longer joint information as the original.
That's correct. Miss Gypsy Blanchard was charged initially, and it now just lists Mr. Nicholas Godejohn. Any objection to that, Mr. Perry?
No, Judge, I think he also eliminated language that said by stabbing her and cutting her, I believe it originally said.
Yes.
So we have no objection. I mean, it does kind of affect our instructions, so I have to redo those a little bit because I was kind of using that language, but that's no big deal.
All right.
But I have no objection to the motion.
And this conforms to what I think is on the death certificate, stabbing versus stabbing and cutting, as I recall. Okay, so we'll show the amended information being filed. The court case is at an elevated security level. A copy will be made available to the media if they want to see the amended charge. All right, then the defense has filed a motion in limine. That was filed, I guess, on Friday. The state has filed a response as to paragraph 6. Is that correct?
Yes, sir, in the defense motion, the paragraphs did deal with different topic areas, and so we'll probably be alternating some of the arguments. We did file a written response to the one paragraph.
Okay, let's go through the motion in limine then. Paragraph 1. Well, not paragraph 1. The first motion in limine, which is stated in paragraph 2, is getting into whether or not the public defender's office was representing the defendant. I'm assuming the state has no objection to that. Paragraph 3 is also experts hired by the public defender's office. I'm assuming you have no objection to that.
It's relevant whether an expert has worked for one party or the other party. Specific to the public defender's office, I agree, but with regard to whether the expert has worked for the state or the defense, that is certainly relevant.
Oh, I would agree with that. I just don't want you to be mentioning that for public defender's office. Paragraph 4, sexual misconduct. This is sort of a area that I'm not aware of. Are you getting into sexual misconduct?
It's very broad, Judge. I guess a lot would depend on what's classified as misconduct. To give the court a little background, there certainly is going to be evidence of a sexual relationship between the defendant and co-defendant, Gypsy Blanchard, and specifically there are a series of text messages that start about 2 weeks prior to the murder and go all the way up till the defendant is standing at the door. And there's a lot of discussion mixed in with the planning of the murder. There's sexual conversations that are mixed in that are not removable from that content. It also, the nature of it goes to show the nature of the relationship also in terms of who was more controlling, who was more dominant between the defendant and Gypsy, which will be relevant in this case. In addition, there's will be testimony from the defendant's confession, specifically that he had considered raping the victim, Claudine Blanchard, but ultimately decided not to. That obviously goes to his deliberation, his reflection, and that he and Gypsy had sex after the murder. Again, going to his mindset and of events that can't be removed, and it is relevant to ultimately the dynamic between both the defendant and Gypsy Blanchard, as well as his deliberation, his mindset. I don't know, because it's not specified in the motion what the defense is specifically seeking to limit. So all I can do is inform the court that's what the state's evidence will be, and then I suppose I can reply when I hear what the defense is trying to specifically keep out if any of that is involved.
All right. Mr. Perry, are there specific instances?
Yeah, Judge, the most notable thing that we are asking the court to exclude for being irrelevant is this discussion that he has just referenced in Mr. Godejohn's statement to law enforcement, in which she asked him on a couple occasions about having sex with the victim and whether he thought about raping her. It kind of, there's a couple of places where she sort of keeps bringing it up. Matter of fact, when you listen to the tape and you watch the tape, you'll see this ongoing discussion about his sex life, both with Gypsy and other people, as well as the fact that he supposedly considered raping the victim. I just don't see how what one considers committing, when one considers committing a crime that's not the crime charged, how that's relevant. He may have considered a lot of things. That does not prove that he killed her after deliberation. And so what happens is the officer asked him initially, early on, if he had sex with her after she died. And he said, no, he didn't. And they have a discussion of what that would be. Then later on in the interrogation, again, this is an interrogation on whether or not he killed her, she asked him if he considered raping her and thought about raping her. And he did, after questioning the officer, make some statement along the lines that I thought about it, but I didn't do it. And then she asked him repeatedly, will we find your DNA? Will we find any semen? Stuff like that. And he said, no, you won't, because I didn't do that. That's not relevant. What's relevant is why he went in there, and did he kill her, or did he kill her after deliberation? That's what's relevant in this case. With regard to some of the other stuff, there's quite a bit of discussion in some of the things about sexual activity between him and Gypsy. I don't have any objection to the state introducing evidence that Gypsy and he had sex both right after this happened, plus on another occasion. I think that is relevant. I think it goes to her level of sophistication and goes to a lot of things along that line. What I object to is the evidence being introduced that he considered raping the victim, because that is not relevant. And the fact that he considered doing something somehow is now evidence against him. Plus, there's quite a bit of discussion between he and Gypsy about rape fantasies and things along that lines, which, by her own admission, were all consensual. They both kind of engaged in this rape fantasy. They talked extensively about rape, and it was just, to them, it was a fantasy. And she even had at one point made a statement that right after the murder, he raped her. And she's actually said that on national TV. She now admits that's not true, that he didn't rape her, that it was consensual sex, and it always was consensual sex. So my request is that evidence of pornography, which I think there is in some of the police reports quite a bit of evidence about pornography usage, that has nothing to do with this case. Evidence that he had considered raping the victim has nothing to do with this case. And I would ask that that part be excluded from the tape. And then any evidence of the rape fantasies between the two of them, unless it's made explicitly clear that that's just a fantasy between a couple. And that's all that was. So that's the basis of my motion there.
Well, before we got to this point today, I had asked the parties to sit down and come up with an agreed-upon excerpt of the confession tape. And it was my understanding that everybody had agreed upon this will be the segment we're going to play. And now I'm hearing, no, we don't want part of it? So are we going to have to go in and revise this?
Well, Judge, I believe what you asked us is initially the argument was some of the excluded portions of the tape, and whether I was going to ask to include some of those. And that's what I told Judge. I have no objection to the part that's being excluded. I specifically said to Dan, I told him that I objected to this, and he wouldn't agree to that. That's why we're having this issue.
I wish we had had this issue several days ago. It would be a little easier for the jury who's sitting down there gluing their heels.
Judge, if I may respond, I think it isn't, I don't think it should be an issue, because what, in a case of first-degree murder that involves premeditation, what the defendant considered is 100% relevant, specific to the crime. The fact that the defendant himself, prior to murdering Claudine Blanchard, considered doing other acts to her as part of the murder is literally what we very rarely have in a murder case, which is direct evidence of premeditation. He is describing his reflection and his deliberation. In addition, one of the issues in this case will be the defendant's ability to deliberate, and the fact that he's making statements that he considered it and ultimately decided not to because he believed killing her was enough, shows that he understands what he's doing and he has the ability to understand and ultimately not rape her. In addition, the defense knows, as we have taken Gypsy's deposition in regard to that matter, that Gypsy's going to testify that she was aware of the defendant's idea or plan to rape Claudine, and it will be her testimony that she made an agreement with the defendant that he could rape her after the murder as long as the defendant didn't rape Claudine. So again, this all is part of their premeditation and deliberation, and just because it's not charged, if it doesn't matter. It's part of the defendant's consideration going into this crime. Because it's terrible doesn't mean the defendant gets to distance himself from it when he admits it. He admits that he considered it. We're not introducing evidence that on some other occasion he thought about raping Claudine, or on some other occasion he thought about raping someone else. We're talking about his statement of what he considered and deliberated on for this murder.
I'm going to allow that testimony to come in. Mr. Perry, if you want some type of limiting instruction, I will consider it. All right, paragraph 5. Statements that Gypsy Blanchard has told the truth. I think that's really up to the jury to decide, isn't it?
And, Your Honor, I believe what Mr. Perry's referencing here is that during the interview, the detective, as part of getting the defendant to open up and talk about what happened, makes some statements to him that, Gypsy's telling the truth, you need to tell the truth. Obviously, the state, just like any interview, there's lots of statements made by a detective that would be considered hearsay or otherwise comments on credibility. The state's not introducing that statement during the interview for the truth. It is part of the interview, and it is part of what ultimately allows the defendant to open up and talk about what's happened. So that's just basic interview techniques that are on in almost every interview.
So this was the preliminary when the detective first came in and was trying to get him to open up.
It's a little different than what Mr. Chapman just said. My objection is not necessarily the hearsay aspect of it. My objection is that she lies to Mr. Godejohn. And she says, Gypsy's told us the truth. Gypsy had not told her. And the officer knew that when she told him that. So what I'm asking is either that it be excluded, or I be able to introduce, at least insofar as the officer knew Gypsy had not told the truth and that she was lying to Mr. Godejohn. That's all I'm asking. Either to exclude it altogether, or if it is introduced, that I can ask the officer, did you know that Gypsy had not told the truth, and were you lying to Mr. Godejohn when you told him she had told the truth? It's a law enforcement trick. We know that, and they do it all the time. They lie to suspects to try to get them to say they've committed a crime. I just want to be able to make that clear to the jury, because otherwise the jury's left with a false impression the false impression, which is what a trial is supposed to try to avoid, that Gypsy had told the truth. And Gypsy had not. So that's all I want to do is clarify that for the jury so they know Gypsy didn't tell the truth.
Well, in the past, I have routinely allowed cross-examination on detectives' interview techniques. I think that's an appropriate line of inquiry.
I would agree with that.
All right, Mr. Perry.
All right, then that's fine. Thank you,
Does
Judge.
that take care of it then?
Yes, that takes care of that.
All right. Paragraph number 6. That's where you're wanting to exclude Dr. Denny from testifying. And so the record's clear on this. I want to make sure that I'm not misstating anything. This case was assigned to another judge before me. And that judge is the one who entered most of these orders concerning the psychological issues, including the admissibility of the psychological testimony. As I recall, Mr. Patterson, after Mr. Perry raised the issue of diminished capacity, you filed a motion before Judge Holden to conduct an examination of Mr. Godejohn. And I believe if you had not yet received Mr. Perry's expert's information, you at least had a summary of what it was about. And that was back, for some reason I'm thinking maybe in December or so, but you didn't file it under 552, which I think everybody's in agreement that the Carruthers case specifically prohibits a 552 type examination. You requested it under the alternative actually suggested by the concurring opinion,
Yes.
which is under the rule for good cause shown, which the Court of Appeals concurring opinion, that would be Judge Sullivan, said would be an option that one could proceed under. As I understand it, have I stated this correct at this point?
Yes, sir. Just to give a little bit further background, this case was actually set for trial in front of Judge Holden. And very close in time to that trial, the defense moved to endorse Dr. Franks as an exhibit, and we filed an objection to the late endorsement of that witness. Then we had the offer of proof. Judge Holden ruled that he would allow the testimony. At that point, I filed our motion under Rule 25 for good cause shown for a state examination. On December 20th, or 22nd of 2016, the defense agreed to the granting of that motion.
Well, and that was a question I had because there is a docket entry showing Mr. Perry, I believe it says with joint consent, something to that extent.
It says sustained by agreement, because there were discussions at the time of the late endorsement, because we all understood the pretty settled state of Missouri law at that time. There was an agreement that because of the late endorsement, it would be necessary to continue the trial so the state could obtain its middle examination under Rule 25, and then that motion was granted by agreement, and then ultimately, after Dr. Denny did his exam, the state moved to endorse him, and he was endorsed without objection by the defense.
Now, I see in your, would that be a correct?
That is, Judge. Also remember, the Carruthers case didn't exist at the time, and I really had no case law that would have permitted me to successfully argue the state didn't get to do it. So, I mean, you got to look at it from my context at the time. However, the case law came down interpreting the law that was in existence at the time. And the Carruthers case came down and said that the state's not allowed to do that. Now remember, in the Carruthers case, a second mental exam was conducted anyway, as you know. And the Carruthers court excluded it after it was conducted, which is what I'm asking. Because the law has changed on this issue, as the court knows. Diminished capacity is not an injury defense. It is simply making the state prove an element. All it is. It's evidence presented on the element itself. So we're not raising a mental health defense here. in the traditional sense. And for that reason, the state was not entitled to it at the time. And I believe the court ought to do what the Carruthers Court did, and that is, despite the fact that the exam was conducted, to exclude it as having violated the rule 552, which does control the situation.
Although it wasn't under 552, it was under...
I realize that, but
I did for
it's still a 552 motion. I mean, it's a mental health request.
Now, certainly the burden has changed, as referenced in the jury instructions. You're correct that it's not the same as an NGRI. It's my understanding, Mr. Patterson, that you, out of to try to avoid error and out of an abundance of caution, have agreed that you will not introduce testimony concerning your expert's examination of the defendant. Is that correct?
Yes, sir. If I could clarify a couple other points. One, Carruthers is an Eastern District opinion. It is currently pending a motion to transfer filed in the Missouri Supreme Court that has not been ruled upon. That decision is also contrary to prior decisions of the Eastern District in State v. Dixon and State v. Wayne, which I cited in a footnote in my motion. But because of the uncertainty caused by the Carruthers decision, I've spoken with Dr. Denny, and he will be able to testify and form opinions based upon the investigative records and the work done by Dr. Franks, the defense expert, and in order to testify those opinions will not need to refer to his own examination and testing of the defendant. The defense motion is overbroad to exclude Dr. Denny's testimony in its entirety. If we were to say Carruthers control, the only thing that would be excludable is that examination and testing done by Dr. Denny. In fact, Carruthers specifically notes
it affords the state the opportunity to put on an expert,
right,
to challenge basically the basis for the defense expert.
Right, to do exactly what I'm proposing to do. The other important thing about Carruthers is procedurally in that case, there was a writ filed in the Court of Appeals. The Court of Appeals issued a stay order, and that exam was conducted after the stay order. So part of Carruthers is punishing the state, the Department of Health, for doing something in violation of its order. We don't have those facts here. Here the exam was conducted with a court order, by agreement of the defense, and the state is not going to put on, like I said, our expert's examination and testing, only his review of the other matters in the case and the opinions he's able to form based on that.
Well, with that,
First of all, if the court allows Dr. Franks or Dr. Denny to testify, then I'm going to object to what he's suggesting limiting. The reason he wants to limit the testing is that testing is helpful to Mr. Godejohn. Dr. Denny's testing actually was more favorable to Mr. Godejohn than was even Dr. Franks' testing. And so what the state wants to do is the court of exclude the bad part for them and let the rest of it in. If he's going to testify, and he's going to just get up there and just kind of talk about his understanding of autism and what it means and all that kind of stuff, then I say the testing comes in. I think that if we're going to do that, then let's let him tell the whole story. Let's not pick and choose the parts of his testimony we want to present, because it helps you. And so that's what I would say about that.
I don't think that was Mr. Patterson's strategy, but certainly if the defense doesn't have, I'm going to let Dr. Denny testify. If the state does not want to introduce the testing during its direct portion, you may do so. That's up to you what you ask and what you don't ask. Mr. Perry, though, if you want to get into it on cross-examination, I'll allow you.
Well, here's the problem. They want to violate their own motion in limine. They've asked to exclude the examination, which includes the testing under Carruthers, arguing that that applies in this case. And then, when the state agrees to do that very thing, now they don't want to. They've got to pick their poison. They either want to exclude the examination and the testing, or not. Carruthers either applies or it doesn't. If we believe it applies, and when we think about plain error review, if the court doesn't have jurisdiction to order that examination, we shouldn't allow it in. But that doesn't exclude the rest of his testimony.
Well, I think, frankly, looking at the concurring opinion again, I do have authority to allow such an examination. And coupled with the fact that it was consented to I don't think we're talking about a plain error review. Mr. Perry, if you don't want me to, I understand you don't want Dr. Denny testifying at all. That would be
I question his qualifications on these matters, but I think if he's going to testify, the testing comes in. I think the question comment you just made is you didn't think that's what Mr. Patterson was trying to do. I think you just got your answer. That's exactly what he's trying to do. He's trying to keep the bad stuff out for him. I think if you're going to let Dr. Denny testify, it all comes in. I should get a cross-examining with his testing and the results of that testing and all that stuff if he testifies. I've asked the court to exclude him, not to allow the prosecutor to pick and choose which parts of his testimony they want to present to tell half the story. That's my position. If the court's going to let him in, I think it all comes in. I would ask the court to exclude it all.
All right. Well, if he's wanting it all in, Mr. Patterson, I'm assuming you don't have an objection.
That's correct.
All right. Let me ask this. We're still not getting into, though, whether or not Mr. Godejohn had the mental state of mind at the time of the actual incident.
Yeah, that's a different issue, Judge.
That's a completely
I think you've
different
already
issue.
ruled on that.
I've already ruled on that.
Correct.
But I just wanted to make sure, when we're talking about letting the entire report in, we're not letting in that one segment that he did have premeditation.
Yes, the court's ruled on that, and I'm planning on proceeding based upon the court's ruling. I may make a record, and may have requested the court at the time of Dr. Franks' testimony reconsider its ruling, but I'm certainly not going to. I certainly understand that is the court's ruling.
And similarly, we're not going to let in evidence from your expert that Mr. Godejohn did not have sufficient premeditation.
That issue the court has ruled on. The statute is pretty clear, and at least the statute that is in effect right now is pretty clear, and so we understand that. That has nothing to do with what we're arguing now.
Okay. And I'm happy if you want to make an objection in more detail once we get into it.
I anticipate making a record and asking the court to reconsider its ruling. We'll address that when we get there.
All right. And then I believe there was one additional motion.
I think that may have been a motion Mr. B filed.
Your Honor, there's a motion to reconsider the motion to suppress. We would ask the court to reconsider that and the evidence that occurred and arguments made during that.
All right. The court has previously found that the confession of the defendant was made knowingly and voluntarily, and I'm going to deny your request for reconsideration at this point, or deny your request for to exclude it.
And we would ask for a continuing objection.
Any objection, then having a continuing objection on the confession rather than having to say objection to the jury.
No, sir, I think that once the jury is sworn, they'll at least need to make an initial
Yes.
objection because we haven't actually started the trial yet.
Yes,
I believe I'd have to make an objection when the witness testifies, Judge.
that is correct.
So that in order to properly, so we know that, we understand.
Okay. All right. Are there any other pretrial issues we need to
I don't think
discuss?
so, Judge.
I don't think so. Once we're wrapped up with these pre-trial matters, we have just a couple of minutes before we bring the jury in.
Yes. I was going to take a break here for about 5-10 minutes, allow everybody to get themselves settled. Initial instructions. There's the preliminary instruction and then instructions number 1 and 2 that are normally read. Mr. Perry, any objection to that?
No, Judge, they're fine.
Do you have them?
I believe I set a copy on your bench this morning, Judge. Your approach.
Yes, sir. I've been shuffling papers.
It's
So.
those right there with the clean and dirty or tab.
Thank you very much. All right. So, 9:45, if we start at about 5 till 10, will that give everybody enough time?
Yeah.
Yes, sir.
All right, thank you. We'll be in adjournment until 9:55 then.